Hello, my name is Axel Halfmeier and I'm a law professor here at Leuphana University in Lüneburg, Germany. And I will talk to you today about the Musterfeststellungsklage, a recent development in the German law of collective litigation. Now, what is the Musterfeststellungsklage, or in English, the model declaratory action? I think we can only understand that if we look at its historic origins, and those are basically twofold. There are two roots on which the Musterfeststellungsklage is built. One is the long history of associations actions in Germany. Since about 50 years, these play a big role both in public law, in environmental law, but also in private law, for example, in the law of unfair competition and in the law of unfair contract terms. And there, the associations suit or associations action is quite a success story, I would say. It has led, for example, to the elimination of many unfair contract terms by such actions. But the one limitation, or the main limitation of this associations action, is that it's limited to injunctions. So there's no damage claim because the association does not have a damage. So it does have some value in, for example, eliminating unfair contract terms or other illegal behavior by companies, but it does not pose a significant threat or deterrence factor to the company, because the worst thing that can happen for the company is that they must change their behavior or their contract terms, but there's no significant financial risk associated with them. So that's one historical background. The other is the more recent CAPMUC, the famous capital market model procedure that was introduced in 2005 after a flood of prospectus liability cases against Deutsche Telekom. And we have a separate video recorded on that. And that is basically a tool to deal with many individual cases. So there are maybe thousands of individual cases, and then a model plaintiff is selected, a model procedure is run, and then this model procedure is binding with regard to the issues decided in that procedure. And so these two historic developments have been combined now into the Musterfeststellungsklage. It's very peculiar that there is no general group action in Germany, neither opt-in nor opt-out. Both are seen very skeptical by many politicians. Actually, an opt-in group action was proposed by the parliamentary opposition in 2014, but rejected. But then in 2015, when the big Volkswagen Dieselgate scandal came to light, there were many individual cases brought by customers, and also the comparison of the treatment of German customers with the treatment of US customers, who got a quite generous settlement under the US class action. That really led to some more openness towards collective litigation, because the idea was, why are the US customers getting such a much better deal, or any deal at all, in comparison to the German customers? And also there was some time pressure that had built up, because these customer claims under German law would be time barred after the end of 2018. So the German parliamentary majority and the German government proposed and then actually passed in parliament what is now called the model declaratory action. And that's in force now since the 1st of November in 2018. Now, this model declaratory action, it's limited only to consumer law, so only consumers may be affected by it. That was criticized because also small businesses, for example, had also bought Volkswagen cars that were affected, but the government decided to protect only consumers by this mechanism. Now, how does it get started? Here, the interesting thing is that the individual consumers have no possibility at all to start such an action, not even if there are thousands of them, not even if they form a group or something like that, or even an organization. The decision by the lawmaker, by the legislator, was that only what is called qualified entities, and that's a term that we know from European law and also from the history of associations actions, only qualified entities, certain associations or other institutions may bring an action, only they have standing. And actually the German legislator was so afraid of allegedly or possible abuse of this instrument that they limited the group or the amount of possible organizations even more than it is in the traditional associations actions. So mainly we're looking at government-funded consumer associations or other associations with very strict requirements. They must have more than 350 members. They must be more than 4 years registered as a qualified entity. They must be non-profit, and they may not have more than 5% sponsorship by industry. So all of this was designed to limit abusive practices that theoretically were thought to be possible, but it also means that the group of such potential plaintiffs is very, very small. Okay, but this qualified entity can bring this model declaratory action against the defendant company and needs to show that 10 consumers are affected. Then the next step is the registration process. So the model declaratory action goes to the what is called the Oberlandesgericht, the higher regional court, not a lower court, but it starts already at a higher court. And there the idea is that only general issues should be decided by the court. So that's the same idea that we have in the Kapmuk, that there are specific common questions or common issues that are common to all of the individual claims, and only they are the subject of the model declaratory procedure. Registration process means that the action is publicized in a public register on the web, and then individual customers may register themselves, register their claims in this register. And if they do that, and interestingly, in the Volkswagen action that started in November, already 400,000 consumers have registered their claims. This registration has 3 consequences. One is that they cannot bring an individual action anymore, as long as the declaratory action is running. If they already have brought one, then that's suspended. Secondly, very important in the history of the law, the prescription, the time limitation is of the claim, of the individual claim, is stopped. And also, finally, the consumer is then, the registered consumer, is legally bound to the results of the model declaratory action, be it positive or negative. In any case, it has a legally binding effect on the individual claim insofar as the common issues are concerned. Okay, so with the registrations, there must be 50 registrations to make the action proceed, but that has not been a problem, obviously, in the Volkswagen case. The next step is then an ordinary court procedure between the plaintiff, the qualified entity, and the corporate defendant before the Oberlandesgericht. Note that the registered consumers are not parties to this procedure. So they have no right to access court documents. They cannot make statements before the court. The only thing they can do is they can withdraw their registration and by that become free again to bring their own case. But that's very limited. They can only do that until the end of the first day of the oral hearing. So that's very limited and not very good option for the consumers. So the end of the proceeding will be a judgment, or the law also provides for a settlement if that is wished for by the parties. It must be approved by the court for fairness, just like we have in other collective litigation regimes outside Germany. And also then, if there is a settlement, the consumers may opt out of the settlement, and then it would not be binding on them, and they can continue, if they wish, with their individual cases. And there's also a threshold. If 30% or more of the registered consumers opt out, then the settlement in total is not binding and will fall away, and the procedure will go on. If there's no settlement, of course, there can be a judgment, what is called the model declaratory judgment, and that can always be appealed to the federal court. So there is no special condition. So apparently the legislator thinks that the importance of this judgment for many consumers makes it legitimate to bring this always to the federal court for an appeal. Okay, so if that's finalized, then the second stage begins. So you see it's a rather complicated, very long procedure. First the model declaratory procedure, possibly until the federal court. And then if we have the model declaratory judgment, the individual consumers still have, even if it's positive for them, no money. They have no title. So if the defendant then is still unwilling to pay or do other compensative measures, they must sue again. They must bring their individual cases, individual actions before the ordinary lower courts. So in the extreme, if we're looking at 400,000 registered consumers, we are looking at, in the future, possibly 400,000 additional individual actions. And in these individual actions, then, the binding effect of the model declaratory judgment means that those issues, if they are relevant for the individual claim, that have been decided by the model declaratory judgment, they are res judicata. They are binding, legally binding for the individual procedure. Okay, so that's the long procedure that we have here that the legislator has designed. So in sum, what can we say? I think we see a repeated pattern here of lawmaking in Germany. In the Kappmuck, it was a reaction to the flooding of the court with prospectus liability cases. So the lawmaker made a specific tool to deal with that, but only for the capital markets cases. And interestingly, that tool was very complicated, still is, and the original telecom cases that started 15 years ago are still in the court system today and are still not resolved. So now, I think this pattern is somehow repeated because, again, the lawmaker has decided against a general, against a, let's say, trans-substantive collective litigation instrument, but has produced this very specific instrument for consumer law that, again, is very complicated, builds on a two-step procedure, and probably, if we look into the future, will last for another long time if there's no settlement. Do we have any other cases beside the Volkswagen case? Yes, there's one smaller case against a bank, but in general it seems that there will not be a flood of model declaratory actions because the limitation on the possible plaintiffs on standing are so strict, and the capacity of these few institutions is limited, so that they will not have the capacity to bring a big amount of model declaratory actions. And also for the lawyers on the plaintiff side, at least, there is not much to win with these actions. The legislator has capped the fee for the plaintiff lawyer at about 6,000 euros, which will not last very long if you think about it, when on the other side there is a big law firm for the defendant that does very professional and good work. So here the incentives indicate that we'll probably not be looking at many model declaratory actions in the future, and the main one will remain the Volkswagen case with 400,000 participants, and we will see how that turns out in the future. Thank you.